We now come to the second part of our lecture on collective bargaining agreements. We start with the discussion on the concept of certification election. Certification election is the process of determining through secret ballot the SEBA, the sole and exclusive bargaining agent, who will represent the employees for the collective bargaining agreement. Any legitimate labor organization may file a petition for election. And a petition for certification election should be supported by a written consent of at least 25% of all the employees in the appropriate bargaining unit. And also, an employer could also file a petition for certification election when there is a request by the employees to have a collective bargaining. And so there are instances in which a certification election could be conducted. First is if there is already organized labor organizations and there is an already existing SEBA, sole and exclusive bargaining agent. However, its majority status is being questioned. And in such case, the other labor organizations in that entity could file a certification election to determine who has the majority status within a bargaining unit. And then if there is an unorganized establishment, it means that there are not yet registered labor organizations. And there is a petition for certification election coming from labor organizations, even if they are not yet registered with the Bureau of Labor Relations, then that would be automatically be conducted by the med-arbiter. And third would be when the certification of election is upon the request of the employer, when there is a request for the employer to have a collective bargaining agreement with the labor organization in a bargaining unit. Where there are two or more petitions for certification election from the same bargaining unit, ibig sabihin, from the same business establishment, then it will be consolidated with just one mediator arbiter. The mediator arbiter is also called med-arbiter, who will have jurisdiction over these petitions. And he will conduct a preliminary conference to determine the bargaining unit to be represented, the contending labor unions, and the possibility of a consent election. And the possibility if there is a bar to the conduct of certification election, no, and other matters. The contending unions may agree to hold an election if there are two or more contending unions, labor unions within a business establishments, which would want to be recognized as the SEBA, then there could be the conduct of a consent election. And a consent election means an election voluntarily agreed upon by the parties with or without the intervention of the DOLE to determine the issue of majority representation of the workers, kung sino among the labor organizations within that bargaining unit ang mas maraming majority representation, which could be recognized as the SEBA. When there are 3 or more labor organizations in a contest election and none of them receives a majority vote, and or if the majority vote was for no election, then what will be conducted will be a runoff election, and that would be an election between 2 labor unions who has received the highest number of votes, provided that the total number of votes for all contending unions is at least 50% of the number of votes cast. So it could be na there are at least 3 choices na mga labor organizations na pagpipilian, kaya lang yung lumabas nun, ang majority votes would be no union vote. Ibig sabihin, karamihan sa mga empleyado ayaw nila na meron union, no? And in such case, there would be a runoff election. And yung runoff election would now just be between 2 labor unions which have the highest number of votes, provided that yung sa mga votes of all contending unions is at least 50% ng votes cast doon sa consent election. Rerun election refers to the election conducted to break a tie between a continuing unions, including between no union and one of the unions. So if the determination is between no union and another labor union, then that would be called a rerun election. It shall likewise refer to an election conducted after a failure of election has been declared by the election officer and or affirmed by the mediator arbiter. At least a majority of all eligible voters, no? Yung requirement for certification election must have cast their votes. This is yung first majority rule. And the union receiving the majority of the valid votes shall be certified as the sole and exclusive bargaining agent. This is called the second majority rule. Again, we have discussed about the runoff election. Which is also called the automatic second election rule. You take note of the following principles, no? As to the contract bar rule, it means that certification election may not be conducted during the existence of CBA, except within the 60-day freedom period. Remember, in the first part of the lecture, we have discussed about the validity or the term of the collective bargaining agreement. And as to the representation aspect, a certification election to determine the SEBA, the sole and exclusive bargaining agent, for the employees could only be conducted within the 60-day freedom period or 60-day before the expiry of the 5-year term of collective bargaining agreement. And so beyond that 60-day freedom period, then no certification election should be conducted. Also, within the 1-year bar rule, in where there is a conduct of a valid certification election, 1 year after that, no another certification election is to be conducted. Also, in case of deadlock in the negotiation for collective bargaining agreement, that is called the deadlock bar rule, no certification election will also be conducted because there is a presumption that during the negotiation of collective bargaining agreement, there is an incumbent SEBA, there is an incumbent sole and exclusive bargaining agent that is recognized, that will represent as the representation agent for the employees in the bargaining unit. And so no certification election is to be conducted during the deadlock of a CBA, deadlock of negotiation of a collective bargaining agent. Also, when there is a charge of company unionism, you remember, this is equivalent to captive unionism. When there is an allegation that the union is under the control of the management, that becomes a prejudicial question that has to be decided, because otherwise there would be no legitimate union, labor union, that would stand for the interest of the laborers if there is a charge that the union is captive to the employer or to the company. And remember that it is one form of unfair labor practice, no? And it's because if the union is company dominated, it would not really represent the interest of the laborers. And so it becomes a bar for the conduct of certification election. Again, outside the freedom period rule, it's like the equivalent of contract bar rule. No certification election is to be conducted outside of the freedom period rule. Negotiation bar rule, when there is ongoing negotiation with the collective bargaining agreement, then again, there is a presumption that there is a SEBA that is being recognized. And so there should be no certification election when there is an ongoing negotiation for collective bargaining agreement. Who are entitled to vote? All rank and file employees in appropriate bargaining unit, whether probationary or permanent. If that is a labor organization for rank and file employees, then they are all entitled to vote to a certification election, including those who are on temporary disability or who were not present because of illness, vacation, or temporary layoff. Because for legal intents and purposes, they are not permanently terminated from employment, and so they would still have the right to vote in a certification election. Employees who were terminated but who filed a case of illegal dismissal, that unless there is a finality of the determination of their dismissal, or there is a declaration with finality of the validity of their dismissal, then they still have the right to vote in a certification election. Strikers also who seek reemployment, reinstatement. Again, if there is no final declaration as to the validity of their dismissal in a labor case or in a labor dispute, then for all intents and purposes, they are still considered as employees of a bargaining unit. And so they would still have the right to vote in a certification election. You take note of the concept of bystander rule with respect to the conduct of certification election. The employer would have no participation in it. Hands off siya. He would just be a bystander, or he would not have any participation in a certification election, because the certification election is for the determination of who has the majority status that would represent the employees in a bargaining unit for the negotiation of collective bargaining agreement. And so this is within the sole interest of the employees. And so the employer must not take any part in it. The right to participate in policy and decision-making processes. This provision refers to the principle of shared responsibility. And however, a line must be drawn between management prerogative and those that are within the right of the employees to take part in policy making. As with respect to decisions pertaining to corporate planning, chartering of corporate business, and other management prerogatives, no, like acquisition of property, these are not within the right of the employees or their authorized representatives in the decision-making processes of a business. But however, with respect to policies affecting working conditions and labor relations management, then the employees would be given the right, no, to recommend policies or to participate in the formulation of these policies. And that could be part of the terms in a collective bargaining agreement. And so that ends our lecture part 2 pertaining to collective bargaining agreement.